Foundation.
Good afternoon and welcome to the City Club of Cleveland. I am Hugh McKay, immediate past president of the City Club. In 1974, with great bipartisan cooperation, the Legal Services Corporation was created. Since that time, it has played a crucial role in assuring equal justice under the law by remembering that all Americans includes low-income Americans. The Legal Aid Society of Cleveland is a compelling example of the crucial importance of the mission of Legal Services Corporation. The Legal Services Corporation has weathered many challenges and has succeeded in advancing its mission under the leadership of many highly distinguished presidents, including Hillary Rodham Clinton and our speaker today. James J. Sandman was appointed president of Legal Services Corporation in January 2011. He was with the law firm of Arnold & Porter from 1977 to 2007 and served as the firm's managing partner from 1995 to 2005. From 2007 to 2011, he was general counsel for the District of Columbia Public Schools. In his legal career at Arnold & Porter and as a national bar leader, Mr. Sandman was preeminent as a force in pro bono initiatives. He was president of the District of Columbia Bar from 2006 to 2007, served on the bar's Board of Governors from 2003 to 2008. He chaired the D.C. Bar's Pro Bono Committee and the bar's Pro Bono Initiative Working Group, was chair of the District of Columbia Circuit Judicial Conference Committee on Pro Bono Legal Services, and he served as a member of the Pro Bono Institute's law firm Pro Bono Project Advisory Committee, the ABA's Standing Committee on Pro Bono and Public Service, and numerous other boards and task forces. Suffice to say, he has been committed to pro bono. Mr. Sandman is a summa cum laude and Phi Beta Kappa graduate of Boston College and received his law degree cum laude from the University of Pennsylvania, where he served as executive editor of the Law Review. He clerked for Judge Max Rosen of the U.S. Court of Appeals for the Third Circuit. Mr. Sandman received the University of Pennsylvania Law School Alumni Award of Merit in 2007 and was named one of the 90 greatest Washington lawyers of the last 30 years by Legal Times in 2008, and he has received numerous other awards, too numerous to mention. Jim Sandman has said that he has the best job in American law, as there can be no more worthy job than working to assure that our legal system provides real access to justice for all. Please welcome to the City Club of Cleveland, President of Legal Services Corporation, Jim Sandman.
Thank you very much, Hugh. It's a real honor to be invited to speak to the City Club of Cleveland. I've actually been here once before. 36 years ago, I was a summer associate at Jones Day, and some lawyers in the firm invited me to join them at a lunch at the City Club. I remember it vividly. The speaker was Senator Frank Church of Idaho. And I also remember being so impressed with the roster of previous and upcoming speakers. Never did I think that I have the privilege of joining their number. Every day across America, millions of children begin their school day by pledging allegiance to a nation with justice for all. Every day across America, thousands and thousands of people go into courtrooms alone, without a lawyer, because they have no right to a lawyer and they can't afford to pay for one. They confront a complicated legal system built largely by lawyers, for lawyers, an adversary system based on the assumption that you have a lawyer, and their opponent usually does. If you have a lawyer, our legal system works pretty well. If you don't, your chances of a fair shot at justice are slim, especially if your opponent is represented by counsel. My subject today is the contrast between America's promise of equal justice under law and the reality that so many low-income Americans face every day. My perspective comes from two opposite directions. First, as president of the Legal Services Corporation, the largest single funder of civil legal aid programs for low-income people in the United States, I have a bird's-eye view of how the nation's legal aid system is functioning. LSC, as we're known, was established by Congress in 1974 with bipartisan support. President Nixon signed the Legal Services Corporation Act as one of his last functions as president. We are funded entirely with an annual congressional appropriation, currently $348 million. We make grants to 134 independent legal aid programs across the country with more than 900 offices serving every county in every state and the territories as well. No matter where you are in the United States, there is a legal aid program funded by the Legal Services Corporation providing legal help to low-income people. In this part of Ohio, our grant recipient is the Legal Aid Society of Cleveland, founded in 1905, the fifth oldest legal aid organization in the United States. My other perspective comes from 30 years of practice with a big international law firm representing some of the largest corporations in America. I've seen how the legal system works for rich clients. Our legal system today is working differently for rich people and poor people. In the United States, as a matter of federal constitutional law, you are entitled to have a lawyer appointed to represent you and to be paid for by the government if you are charged with a serious criminal offense. But you have no such right in any civil case. Civil cases often involve matters of urgency, importance, and necessity, matters of safety, subsistence, and family stability. You can lose your home. You can have your children taken away from you without any right to a lawyer if you can't afford one. You can be a victim of domestic violence in need of a protective order against your abuser, and you have no right to a lawyer. Yes, every day, victims of domestic violence are forced to seek protection against their abusers alone, without counsel, even if their abuser has a lawyer, because he controls the family finances and is able to hire one. As a practical matter, access to justice in civil cases often depends on whether you can afford a lawyer, whether you can get a lawyer to represent you for free, pro bono, or whether you qualify for and are lucky enough to get representation from a legal aid lawyer. But legal aid societies are overwhelmed with demand and badly underfunded. Today, more than 61 million Americans are financially eligible for service at legal aid organizations funded by the Legal Services Corporation. That is 20% of the American population, an all-time high. But our funding has been reduced by 18% over the past 2 years and now stands in inflation-adjusted dollars at an all-time low. In addition, many legal aid organizations have experienced dramatic reductions in their other sources of funding. The Legal Aid Society of Cleveland, for example, has seen its revenue from interest on lawyers' trust and escrow accounts decline by $2.6 million over the past several years. Studies consistently show that legal aid organizations are able to serve no more than half of the people who seek their help, and many of the studies report much lower percentages. The result is that courts throughout the country are inundated by litigants without lawyers. The statistics for 2011 from just one state, New York, are breathtaking. Last year, in New York, 2.3 million litigants appeared in state courts without a lawyer. 98% of tenants in eviction cases did not have a lawyer. 95% of parents in child support cases did not have a lawyer. And 2/3 of homeowners in foreclosure proceedings did not have a lawyer. We are violating Justice Lewis Powell's admonition. Equal justice under law, he said, is not merely a caption on the facade of the Supreme Court building. It is perhaps our most inspiring ideal as a society. It is fundamental that justice should be the same in substance and availability without regard to economic status. Why is it that legal aid is so underfunded? Why has Congress and why have a number of states reduced funding for legal aid? I think the answer is that legislators often regard funding for legal aid as just another discretionary domestic spending program, as a poverty program that must be reduced because of budget pressures. When I took on my present position last year and began to lobby for funding for LSC on Capitol Hill, my first experience as a lobbyist, when I went to ask for more money, I was often met with a look that said, "Didn't you get the memo? Everybody's got to take a cut." But providing access to justice is not just another discretionary program. Access to justice is a fundamental American value, a nonpartisan value. It's about who we are as a country and what we hold ourselves out to the world to be. The very first line of the Constitution cites establishing justice as a core purpose of our national government. We, the people of the United States, in order to form a more perfect union, establish justice. The framers emphasized establishing justice as their goal even before they mentioned providing for the common defense or ensuring domestic tranquilities. We've inverted their priorities. I don't think their ordering was an accident. They recognized that a well-functioning, accessible system of justice is essential to societal stability. You won't long have a nation to defend or worth defending without it. It's about the rule of law. Legal rights are worth nothing if you don't have a reliable way to enforce them. This is what the great Judge Learned Hand of New York meant 51 years ago when he said in addressing the Legal Aid Society of New York, "If we are to keep our democracy, there must be one commandment: thou shalt not ration justice." Hard times test values. They force you to make difficult decisions about what you can't live without and what is dispensable or discretionary. These times are testing our national commitment to equal justice. Were the framers speaking in the first line of the Constitution about a value, justice, that must cede to the vagaries of the economy? Do we mean it when we pledge allegiance to a nation with justice for all? Or is there a postscript to the pledge, if we think we can afford it? I believe our national commitment to access to justice is very real. But I don't think the connection between the lofty principle and having counsel in a civil proceeding is commonly understood. Even within the legal profession, there are many smart, well-informed people who are unaware of the current crisis in legal aid and of what the crisis means for access to justice, to the victim of domestic violence seeking a protective order against her abuser, to the elderly couple trying to fight a wrongful eviction, to the veteran who's been denied benefits she earned by serving her country, none of whom is able to obtain legal assistance. People do not know that less than half of those who qualify for and seek legal aid actually get it. They do not know how many millions of people are forced to navigate our legal system by themselves. So what can we do about this state of affairs? I offer 4 suggestions that I believe can, over time, dramatically increase access to justice for those unable to afford a lawyer. The first and most obvious is to increase funding for legal aid programs from all sources, public and private, in every state. But of course, that will not just happen. Those of us in the legal aid community need to do a much better job of educating the rest of the legal profession and the public at large about the value of what we do and why they should care about it. In this effort, there is emerging a new and influential category of allies and advocates. The Chief Justices and Justices of our state Supreme Courts, the people responsible for the administration of justice in state courts, who see close up the consequences of what I have described. People like Chief Judge Jonathan Lippman of the New York Court of Appeals and Chief Justice Wallace Jefferson of the Supreme Court of Texas have persuaded their legislatures to increase funding for civil legal aid. In New York, the legislature this year has appropriated $40 million for the current fiscal year, more than 10% of LSC's budget for the entire country. Justice Jess Dickinson of the Mississippi Supreme Court, Chief Justice Carol Hunstein of the Supreme Court of Georgia, and Justice Nathan Hecht of the Supreme Court of Texas write and speak on the importance of legal aid frequently. And when they do, they are heard very differently from how traditional legal aid advocates are heard. They are heard differently from how I'm heard. They are a bipartisan group spanning the political spectrum. They are and are perceived as objective. They speak of the effects on the entire legal system for everybody, including those who can afford a lawyer, when the courts are overwhelmed with unrepresented litigants who take more time because of their unfamiliarity with the system. And they see the quality of justice suffer when people who have valid claims or defenses lose their cases only because they did not know how to present them. Advocates like these are making a difference in generating more funding for legal aid. One of my goals as president of the Legal Services Corporation is to bring the message of the reality of justice in the United States today, the crisis that we face, to new audiences like this one, who may never have heard the message before, and to begin to do a better job of explaining what the situation is. The character of our country is at stake. Second, we need to simplify and streamline our legal system so that it works better for those who don't have a lawyer. The system need not be nearly as complicated as it is. There is no reason why the language of the legal system has to be gobbledygook for those who were not trained in the law. Court procedures are not only often Byzantine, but variable from one county to another within a state, and sometimes even from one judge to another within the same courthouse. In recent years, partly because of technology initiative grants made by the Legal Services Corporation, progress has been made in putting plain language court forms online with instructions for completing them. Some jurisdictions now have software programs available that allow self-represented litigants to answer a series of interview questions that are then used to automatically complete a required court form. It works like TurboTax. I use TurboTax. I relate to TurboTax. I do the interview and it completes a 1040 for me. This is what is beginning to happen with court forms. We need much more of that. We also need to permit non-lawyers to assist in legal proceedings to a much greater extent than they are permitted to now, in ways analogous to how medical technicians and nurse practitioners are making medical treatment more cost-effective and more widely available. Of course, the bar might resist some of these measures, and already has in some places where lawyers have felt economically threatened by simplified forms and the expansion of non-lawyers' roles. But we can never let the self-interest of lawyers impede access to justice. If people want to have that fight, bring it on. I'm prepared to wage it. Third, we need to increase private attorney pro bono involvement with legal aid programs dramatically. Although many legal aid programs, like Cleveland's, have long leveraged their limited resources with thousands of pro bono hours of time from the private bar, we can and must do much more. The Legal Services Corporation's Pro Bono Task Force released a report last month that provides a catalog of recommendations for how to do this, and we have begun work on implementing those recommendations. In recognition of the difference pro bono service can make in addressing the huge unmet need for legal assistance for people of limited means, New York has just adopted a rule that requires every applicant for admission to the bar to have performed at least 50 hours of pro bono legal services. I think we need more initiatives like that. I do want to emphasize, though, that pro bono lawyers will never be a substitute for full-time legal aid lawyers. Pro bono lawyers need the infrastructure of robust legal aid organizations to do client intake, screen cases, and provide training, mentoring, and support in areas of practice that are often outside the mainstream of the pro bono lawyer's regular practice. But pro bono lawyers can be a critical supplement to the resources of legal aid societies, allowing them to serve thousands of additional clients each year. And finally, we need to equip legal aid organizations with the business tools to manage their resources to maximum effect, to use solid data to determine what legal services yield the best outcomes for clients, and to apply the same rigorous analyses to their own performance that corporations use to assess the performance of their law firms. This is one of my top priorities as president of the Legal Services Corporation, and I am pleased to be working on this with one of the nation's leaders in the use of data to manage the delivery of legal services to low-income people, your own Colleen Cotter, Executive Director of the Legal Aid Society of Cleveland. There are a number of people here today from the Legal Aid Society of Cleveland. I want to call them out. These are people who, at substantial personal sacrifice, are devoting their careers to the service of low-income people who have nowhere else to turn. Legal aid lawyers as a group are the lowest paid lawyers in the legal profession. They labor day in and day out with crushing caseloads, with the emotional burdens of their clients' circumstances, with the heartbreak of knowing how many people they are unable to help, and with the insecurity of precarious funding. But they do it with a resilience and a professionalism and a passion and a commitment to their clients that is absolutely remarkable and that the richest clients in America would love to have. They are making America's promise of justice, reflected in the first line of our Constitution and the closing words of our Pledge of Allegiance, real for thousands of people. I think they are heroes. I thank them for all they do to serve the highest ideals of our profession and of our nation. I commit to them and to all of you to do everything I can to justify their faith in equal justice. Thank you.
We're very honored today to welcome to the City Club of Cleveland James J. Sandman, President of Legal Services Corporation. We will return to our speaker in a moment for our traditional City Club question and answer period. We encourage you to go ahead and formulate your questions now. Please remember to keep them brief. We welcome all of you here and those listening to 90.3 WCPN Idea Stream, WCLV, WTAM, or one of the many radio stations across the country. Our television broadcast partner is WVIZ PBS Idea Stream. Television broadcasts of the City Club are made possible by Cleveland State University and PNC. Our live webcast is supported by the University of Akron. Closed captioning of our programs is made possible by the Nordson Corporation. Today, we welcome guests at tables hosted by Baker Hostetler, Cleveland Marshall College of Law, Gallagher Sharp, KeyBank, the Legal Aid Society of Cleveland, the Ohio Legal Assistance Foundation, and Taft Stettinius. Thank you for your support. Today is the annual Forum on Leadership, made possible by a special memorial gift from the friends and family of Colleen Shaughnessy. Joining us at the head table today are Michael Crystal, Jerry Sheehan, Gene Shatton, and Larry Oscar. Will you all please stand and be recognized? Thank you very much for your support. Now we'd like to return to Mr. Sandman for our traditional City Club question and answer period. We welcome questions from all of you, including guests. Holding the microphone today is City Club Development Associate Nancy Ilg and Program Director Carrie Miller. First question, please.
Mr. Sandman, over here. The problem of access to justice is obviously something that extends all over the world. In your experience, is there anywhere else in the world, particularly in Western Europe or Northern Europe, where they're handling the problem any better?
Thank you for the question. Yes, the issue is handled better in some other parts of the world, particularly in Canada, Australia, and the United Kingdom, although I know the United Kingdom has recently reduced its funding. But in those countries, there is a guarantee of a right to a lawyer and a legal aid system that covers both criminal and civil matters. And funding is much more robust than it is in the United States. I think that's very curious because our legal system originated in England. How is it that we don't have that same aspect of our legal system here? I was on a panel last year with lawyers from the UK, Canada, and Australia, and it was awkward, actually. It was awkward to be the American in that group and to hear about the level of funding they have. And I asked one of my panel mates, the one from the UK, when did this start in the UK? Because here in the United States, support for legal aid really came in two tranches. The first was about in the early 20th century when voluntary legal aid societies were formed to provide philanthropic support for legal aid, often for new immigrants. And the second was in the mid-1960s when federal legal funding began under the auspices of the Office of Economic Opportunity in the War on Poverty, later folded into the Legal Services Corporation. So I was curious what the origin was in the UK, and I was told that the answer was it was shortly after World War II. And it was part of the reformation of society after the war to figure out what a good society does. And there was a particular advocate who was a lion of the bar in the UK who took this on as a cause, who had such credibility and was so persuasive that he carried the day. It's a demonstration of the importance of leadership on an issue like this. But I think also in Western Europe, there are countries that are more effective in providing legal aid to people. There are rankings of access to justice internationally that rank countries based on, among other things, the availability of lawyers to people who cannot afford them. And the U.S. doesn't look very good on those charts. So I think there is something we can learn from other countries.
Hi, Jim. You mentioned a New York requirement of public service for admission to bar. A number of progressive law schools, including one that I know you're particularly familiar with, have on their own adopted requirements of that sort for graduation. Wonder if you could comment on any efforts by LSC with respect to American Association of Law Schools, American Bar Association, to try to get those requirements generally adopted across the country so that when young lawyers, newly minted, come out of law school and take the bar exam, they've already got some experience along those lines in terms of pro bono work.
I received an email about that just this morning, very timely. Requirements for law schools are, the American Bar Association accredits law schools in the United States, and if a mandatory pro bono requirement were to be a part of accreditation, it would be the American Bar Association that would be responsible for implementing that. The Board of Directors of the Legal Services Corporation hasn't yet taken action on any initiative to require mandatory pro bono before people are admitted to the bar, but I know that states beyond New York are already looking into the possibility of adopting a similar rule. New Jersey and California, for example, have begun exploring whether they should do that. I heard Chief Judge Lippman of New York speak on this subject just two days ago. The judiciary controls the rules of admission in New York, and he can pretty much do what he wants to, and he did. And when he first proposed this rule back in May, he came in for some significant criticism for it. People criticized from all angles. Some said it didn't go far enough. Why should the mandatory requirement for a pro bono be imposed only on new members of the bar and not on people who are already members? Why didn't he do more consultation and deliberation before he just made this announcement? But he went ahead anyway. As he said, he didn't take any poll because he did this in response to the crisis he sees in the courts of New York with so many people being unrepresented. And his view was that in a crisis, you respond with leadership. You don't appoint committees to study the problem for years or decades. He did appoint a committee to deal with the particulars of implementing the new requirement. And they came up with a rule in 4.5 months. It's now been announced, and it will be effective on January 1st of 2013. That's leadership. So it's still early days with that requirement and what might be done with it nationally, but I think it's generated a lot of attention and also increased the focus on the need that gave rise to Judge Lippman's requirement.
Appreciate that you're lobbying Congress to get money for legal services, but beyond the polite hellos and the blank stares that I'm sure you get, do you have a strategy for harnessing the grassroots in targeted congressional districts of legal practitioners and poverty advocates or poverty service advocates to change minds of the members who might not be well disposed toward your message?
Thank you for your question. I don't have a strategy, and the answer is I can't. I am forbidden by law from engaging in grassroots lobbying. I cannot encourage other people, ask other people to lobby. The law does permit me to lobby directly on behalf of the Legal Services Corporation on legislation directly affecting the Legal Services Corporation. The most I can do is to educate people about the problem, but I cannot be part of any grassroots strategy to try to take legislative action.
I just wanted to know if you would mind elaborating a little more on your plan to develop some sort of metrics, what time frame and what you're hoping to achieve with that.
Yes. The question relates to my plans to develop metrics to help measure the performance of legal aid organizations so that they might serve their clients as efficiently as possible. In a time of scarce resources, you want to be sure that you're directing whatever dollars you have to the places where they can be used most effectively and where you're getting the biggest bang for the buck. This is a difficult exercise across the network of legal aid programs that the Legal Services Corporation funds because those organizations differ from one another so much. Some are statewide programs, and they may be the only program in the state. Other are telephone hotlines that are part of a network within the state that includes other legal aid organizations not funded by the Legal Services Corporation. There are other funders out there at the state level that have their own ways of looking at the programs that they make grants to, and we don't want to interfere with what they're doing or to complicate reporting requirements for our grant recipients. So we have a grant from the Public Welfare Foundation to do research on this subject and to institute some changes in the information we get from our grantees, and also to help us develop what we call a toolkit to offer to legal aid organizations so that they can choose different ways of figuring out what works best for them in their local circumstances to measure their results and figure out how they can serve their clients best. The grant takes us through the end of next year, so I hope that by then or by the beginning of 2014 we'd be in a position to do something. This will be a collaborative process where we'll work with and learn from legal aid organizations. I don't think it's going to be possible to mandate any kind of uniform national standards for these 134 different legal aid programs. I think we need to recognize the need for some flexibility. I'll give you an example that came up in a meeting I was in this morning. One of the things that legal aid organizations do very effectively is community education to inform communities about their legal rights before legal problems arise. It's a preventive strategy. It's like preventive medicine. And that can be a very wise investment of money. Why wait until the problem arises, particularly if you know that you don't have the resources to help everybody who comes to your door? How do you measure the effectiveness of a community education program? I don't have an easy answer to that question, and that's the kind of thing I think we need to be very careful of in pursuing this exercise. But my perspective on this really comes from my experience in private practice. Not long after I began at the Legal Services Corporation, I was at a meeting with directors of a number of legal aid organizations and expressed my view that some additional measurement and data and performance assessment would be helpful. And he looked at me and said, "You can't measure what we do. We're lawyers." And I thought about it. I didn't say this at the time, but I thought about it and later realized, rich clients measure what their lawyers do all the time. The most sophisticated corporations in America are always looking at how the outside law firms they use are performing. They compare them against each other, and if a firm doesn't measure up, they replace that firm with another one. And the lawyers in the big firms in that situation, they don't like being measured any better than legal aid lawyers like being measured. But I think the rich clients know what they're doing. I think they're making more informed decisions. Who's going to do that for poor people? Who's going to look at their lawyers in the same way that rich clients look at theirs? I think there needs to be some parity there and some lessons that we can take from the wealthier segment of society.
Jim, you know you've been my hero for decades, and precisely...
I didn't pay her.
No, but precisely because you've been willing to push the envelope on issues of equality and justice in multiple fora. So I'm struck that conspicuously absent from your list of strategies is the one that would really be most obvious to a litigator on complex litigation, which is, why isn't it time to learn from the plaintiff's bar and get rid of the shackles that prevent legal services from taking on the mass case, the complex litigation? I mean, why do it one house at a time when we could have taken on the mortgage crisis and tens upon hundreds of millions of dollars could have come both to legal aid and justice for those who have been hurt?
Charna is referring to limitations that Congress has required on organizations that receive funding from the Legal Services Corporation. The limitations don't permit LSC-funded organizations to do class actions, among other things. We, the Legal Services Corporation, our board of directors, and I accept the appropriations that Congress makes to us with the limitations that Congress imposes. And we do not take a position on the restrictions. There are many other legal aid organizations in other parts of the country. I know that here in Cleveland, the Legal Aid Society is the only such organization. But there are other legal aid organizations that do not receive funding from the Legal Services Corporation, and they can do what they choose to. But I'm not permitted to take a position on that.
What was the all-time high level of annual funding by Congress, and are there any particular champions in the present Congress of your mission?
Yes, the all-time high in absolute dollars was only 2 years ago in 2010. It was $420 million then. In inflation-adjusted dollars, I believe the high point would have been 1980. In inflation-adjusted dollars, that would have been $600-some million, close to $700 million, I believe. And there are a number of champions in Congress, bipartisan champions. We do enjoy support across the political spectrum. Among our proponents is the chair of our House Appropriations Subcommittee, Congressman Frank Wolf of Northern Virginia. We have many supporters in the Senate. Senator Barbara Mikulski chairs our Senate Appropriations Subcommittee, the Subcommittee on Commerce, Justice, Science, and Related Agencies. Senator Tom Harkin of Iowa. There are many. If I go much farther in naming names, I'm going to offend somebody. But when we do talk to people in Congress, our effort is to get to talk to as many people as we can. I know from personal experience, it is a terrible mistake to stereotype whether or not a particular member of Congress might support funding for the Legal Services Corporation based on his or her political party affiliation. Like all stereotyping, it's usually wrong. There are individuals out there who have different views on these, and you need to recognize that and be respectful of it. But we do have bipartisan support.
Mr. Sandman, thank you so much for speaking with us today. I wonder if you could talk a little bit about the parts of the country where you're most concerned that legal aid services aren't being provided at the level that you wish they were.
Yes, thank you for that question. You make an important point. Access to justice in the United States today is very much a function of geography. It depends on where you live. And the reason is because there is enormous variation across the states in the extent to which they provide funding for legal aid. Back to the previous question about international legal aid. This is in contrast to Canada, where most of the funding for their legal aid system comes at the provincial level, not at the federal level. But if you look across the 13 provinces of Canada, as I have, you see much more consistency of funding than you see across the United States. Only one province stands out, Alberta, and I think it's because they're rich. They have oil and gas. But there's much more uniformity there. How did that happen in Canada, that the provinces all came to independent conclusions about the value of legal aid that were so consistent as contrasted with the different judgments that are made in the United States? There are some states that are very generous in funding legal aid. We see it in the degree to which the legal aid organizations to which we make grants are dependent on the Legal Services Corporation for funding. In Maryland, for example, the Legal Aid Bureau of Maryland, a statewide program, gets only 18% of its funding from the Legal Services Corporation. Legal Services of Alabama, by contrast, gets 86% of its funding from the Legal Services Corporation. So their fortunes depend very much on what happens with our congressional appropriation. The Mountain West, the states in the Mountain West are more dependent on LSC funding. They typically get more than 50% of their funding from LSC, in some cases 70% or more. Colorado is an exception. Legal Aid of Colorado gets only 30% of its funding from the Legal Services Corporation. I hate to generalize, but I think the Northeast and the West Coast are generally among the most generous, but there are pockets throughout the country. And I'm too new at my job to know what the history is and how that variation developed. There is a network of people from all of the states who are familiar with whatever funding the state provides, who convene regularly to compare strategies and see what's working and come up with new ideas for funding in their own jurisdictions. But there is a lot of variation out there. Which, just one more thing. I mean, why should this is a national value? Why should there be so much variation? I think one of the purposes of the Legal Services Corporation was initially to provide a baseline across the country, and we've deviated from that.
Good afternoon. I read that legislation has been proposed in Ohio to allow juveniles to have attorneys. I don't know if it's to allow them or to require them to have attorneys, and I'm not a lawyer, so I don't really know the details about it, but I thought it was an interesting idea, and I wanted to ask you, are you familiar with that proposed legislation, and are there any other states where that is happening?
I just heard about that legislation yesterday for the first time, and I only heard about it to know that there's something going on, but I don't know what. So I'm sorry that I'm not able to answer the question.
Mr. Sandman, can you talk a little bit about, I don't know if this is a fair question or not, but can you talk a little bit about, how do I, when I'm educating people in the community about this, talk about the outcomes of not having quality representation for people in the courtroom? So, I have to assume that there is some correlation with mandatory sentencing and things like that, are prisons and, are these showing the outcomes of not having quality representation?
There haven't been a lot of studies about things like that, and that's one of the challenges that we face. I think we need to engage some solid academic research on these topics. There are what I would regard as analogous studies in other areas that I think we might learn from. In my experience at the DC Public Schools, for example, I learned that there are studies that correlate test results for third grade boys in urban public school systems with incarceration rates later on. And I am told, I don't know if this is true, that there are some states that do their planning for future prison populations based on data like that. I think that if we had the money to do the research, we would be able to show some very positive correlations between good outcomes in legal aid cases where, as a result of having a lawyer, someone wasn't forced into homelessness because they were allowed to stay in their home. Somebody was able to keep or get a job because of action that a legal aid lawyer was able to take. And certainly for victims of domestic violence who were able to get help in getting out of an abusive relationship, to get their lives back together, to either get a job or get back to a job, I think I can predict what the result would be, but there aren't strong studies out there yet that I'm familiar with.
I wanted to expand on the question about differences in services by geography. And my impression is that rural areas would be much more difficult to service than urban areas, and particularly this is based on some experience in western North Carolina where you have one major urban area in Asheville and a lot of very small counties. And is that true across the United States? Is there any states that have done a particularly good job of providing legal services in rural areas where people tend to be less wealthy, et cetera?
You are correct that it is a challenge. States that have widely dispersed populations and that cover large land areas pose real challenges to the delivery of legal services. But there are some good models out there. Montana, for example. The legal aid program that we fund in Montana is a statewide program. Montana is the fourth largest state. It has, as I recall, 7 people per square mile. I was in Helena, the state capital, a few weeks ago. There are 30,000 people in Helena. And I was told in planning for my visit that there are only 2 taxi cabs in all of Helena, and that they're not reliable. But there's a great executive director out there, Allison Paul, and one of the things she has mastered is the use of technology to reach people in rural areas, to use the internet, to use text messages. That's her challenge. That's the area that she covers, and she has to figure out a way to deal with it. But there are other places where that won't work. I also visited recently a legal aid program on the reservation of the Navajo Nation. The Navajo Reservation is larger than 8 states. The legal aid program has 10 offices within that service area. I began to get a sense of what some of their challenges might be when I was met at the airport by a lawyer who works for the program and was telling me that he just bought his car new 4 months ago. It had 14,000 miles on it in 4 months. Huge distances and no good way to get from one place to another directly on the reservation. And also significant challenges in using technology as an alternative means of service delivery. There aren't a lot of cell phone companies building towers on the Navajo Reservation, and broadband access isn't there. In fact, it's such an issue that the lawyers who work for the program, many of whom come there straight out of law school and work there for 2 or 3 years, often aren't able to get cell phone coverage or internet access where they live. Imagine being a 20-something today, having moved to the Navajo Reservation and having no access to your friends and family on your cell phone or your internet. I don't know how you'd function. And an additional challenge that I like to point out to those people who make the argument that pro bono can be a substitute for well-funded legal aid organizations. In Georgia, 70% of the lawyers in Georgia are concentrated in the 5-county Atlanta metropolitan area. 70% of the poverty population in Georgia is located outside the 5-county Atlanta metropolitan area. There are 6 counties in Georgia that have no lawyers at all in them. There are 29 counties that have between 1 and 5 lawyers, and another 26 that have between 6 and 10 lawyers. Those lawyer counts include every active member of the bar, the judge, the public defender, the prosecutor, and the lawyer who represented the bank on the mortgage that's now in foreclosure where a person needs legal help and can't take the case pro bono because she has a conflict of interest. You tell me how you're going to use pro bono in a state like that as opposed to having regional legal aid offices around the state that can be closer to where people live. And finally, although I do think that technology does have a very important role to play in expanding access to legal services in rural areas, I don't think you can ever underestimate the importance of personal connection between lawyer and client. It's a different relationship when you don't have physical proximity and when you cannot be in the same room with the client that you're serving. So we're making progress there. That is one reason why the Legal Services Corporation, in the technology initiative grants that it makes, has focused heavily on developments that might expand access to justice in rural areas.
Mr. Sandman, welcome to Cleveland.
Thank you. Welcome back.
Welcome back to Cleveland.
Thank you.
Sequestration, which is across the cuts on federal budgets, is to occur on January 2nd, 2013, unless there's some additional statutory changes or legislation. How will that affect your organization? How will that affect the local legal aid society here in Cleveland? And are there steps being taken or planned to make up for the shortfall?
If sequestration were to become effective, our budget would be reduced across the board by 8.2%. And each of the legal aid organizations that we fund would have their funding reduced by 8.2%. Anything that's done to offset that reduction would have to be done at the local level with alternative sources of funding. The Legal Services Corporation is such a small part, an infinitesimal part of the federal budget, that any strategy to deal with sequestration focused on us alone would be pointless. So we will rise or fall based on what happens on sequestration as a whole.
Can you make a comment on the importance of leverage? For instance, here in Cleveland, we take the $2-some million LSC appropriation, combine that with donor dollars, and that translates into a $40 million benefit for Northeast Ohio. And how do you use that part of the story in some of the work that you're doing to tell the story of the importance of legal aid?
That's a great question, and thank you for it. That's a very effective argument to make for federal funding, that federal dollars are leveraged and that the money that we provide generates public-private partnerships where the federal money is then expanded at the local level with funding from other sources. Congress likes that idea, the idea that federal dollars are not the only support that appropriations recipients are relying on for their work. So it's something that we point to regularly. We also, we have statistics on the extent of pro bono work done at the legal aid societies that we fund, and that too is very effective. I think you allude to something else, though, which is that legal aid can yield economic benefits and can result in savings in governmental expenses by averting problems. And there are efforts out there today, some have been done already, to try to quantify the economic benefits of legal aid, to show what they bring into communities and what money they save governments by avoiding, for example, homelessness, by getting victims of domestic violence out of abusive relationships and saving medical costs and getting them back on employment rolls. There is a business case to be made for funding legal aid, that this isn't just money spent. It's money well spent that will yield returns and is a good investment.
Today at the City Club of Cleveland, we've been listening to a forum featuring James Sandman, President of the Legal Services Corporation. Thank you, Mr. Sandman. Thank you, ladies and gentlemen. This forum is now adjourned.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.